Committee. And Grievance Committee is the organization that is monitoring and helping the MCLE Commission run the MCLE program. So a couple of housekeeping things while we let the rest of the folks crawl up the 6 flights of stairs. So anyway, the restrooms are outside, right near the elevators that don't work. And please, maybe by the time we all leave, the elevators will be working. And cell phones, I've turned off my cell phone, which I forgot to do last Thursday at the professionalism seminar, so please turn off yours. All right, and let's see what else. And we're going to try to save questions to the end. And I'm hoping that by the time we're all done, maybe there will not be that many questions. So we will see. So I'm hoping that we will get there. Let me start off by talking just a little bit about the overview of the rule and how this rule came about and why it's structured. And then Michael's going to run through a lot of the specifics and we'll try to fill some things in. But MCLE, as many of you know, in Connecticut was sort of been a little bit of a tortured path. There was a time prior to 1995 that there were some rules that were proposed, and in 1995 there was a rule that was proposed that went up. It was approved by the bar associations and then went up to the judges and didn't get passed for a lot of different reasons. And then after that there were a variety of different types of rules that came up, but mainly the objections to the rules were that, one, it cost too much to set up an expensive system within the branch, and two, it would just caused more administrative work for lawyers that was sort of unnecessary. So a group of us, myself, Lou Pepe, and Larry Marizio, tried to work on a rule that would come together and not cost hundreds of thousands of dollars to set up an administration, and would leave a lot of the administration really up to the individual lawyer. That was really just a self-reporting system. But the goal is to try to have lawyers look at, take some bar associations, create groups, create some really good continuing legal education for lawyers. That was the goal, and it says that in the rule. And I think by the time you all walk out of here, I'm hoping that there will be a lot less anxious people about what's going to be required and what we're going to have to do. All right? So we'll start off with Mike. He's going to start off with our slides.
Thanks. And before I begin, I just want to note that if we go through everything today and you're still hopelessly confused and want to rewatch or revisit this issue again, we are taping today's presentation. So if you heckle us, that'll get picked up also. And we did plan to post today's presentation on the Judicial Branch website on the MCLE dedicated website, which I imagine most of you found your way to actually register for today's course. So again, at the end, if you want to watch the course again, or people say, gosh, you went to this MCLE seminar, I wish I had known about it, feel free to send them the link. They'll be able to watch everything, including today's question and answer session, and we will also post the handouts that you got in a spiral-bound notebook. We will have posted up on the website, including today's PowerPoint presentation. So hopefully that will help you and others.
And one other thing is we're going to try to, for those of you that are from other bar associations, we've got Bridgeport Bar Association this Wednesday, Stanford Bar Association I'm going to try to do sometime in December, and anybody else that's from a bar association, whether it's Tolland or New London or some of the others, please, if you want either Michael or myself or both of us or somebody else from the commission, we will come out and do the same presentation for bar associations. We did the Hartford Insurance Company a couple of weeks ago, and same thing with those types of groups.
Yeah, I think we're covering the Hartford Bar Association, the Connecticut Bar Association, local groups down in Fairfield County, and it'll be this presentation all over again. So if you think your local bar would benefit from it, just let Fred and I know. So let's just talk a little bit about today's agenda. We're going to do a brief overview of the rule. We're going to talk about how to comply with the rule, specifically the delivery and content provisions of the rule. We're going to talk about how you calculate your credits, including how you calculate your credits for being nice enough to sit here today, how you report your compliance, oversight and regulation of the rule, any other additional information, including contact information for both the MCLE Commission, which implements the rule, and the Statewide Grievance Committee, which enforces it, And then at the end of all this, we will have a question and answer period, and we will be here until you're done asking questions or they kick us out at 5 o'clock, and we all have to climb back down the stairs. So, let me just say, let's talk a little bit about the overview of the rule. There we go. Are we, no, we're not perfect. There we go. I should say the Hartford, which is a beautiful office building, could not get their PowerPoint to work at all on the day we were there. So we're way ahead of the game right here. So the practice book section that's in play is practice book section 2-27A. And as Fred mentioned, MCLE sort of has a long journey from the first time it was proposed over 20 years ago to the new rule that will take effect on January 1st. The rule went through the Rules Committee last year. Fred was one of the drafters of the rule. It was adopted by the judges finally in June of 2016 with a January 1 effective date, January 1, 2017. So you don't have to take any CLE until January 1, 2017. You are still in a voluntary time to take CLE until the end of the year. We've always encouraged it, but it's never been required. As of January 1, 2017, and going forward, it will be required. You're reporting how you comply with CLE and show that you have complied with the rule begins in 2018. It's a look-back provision, and you will do so on your attorney registration form, which we will get into later into today's presentation. It's a self-reporting honor system, so you're not going to be filing anything with either the MCLE Commission or the Statewide Grievance Committee on a course-by-course basis. So if in January you attend a CBA, CLE seminar, and they give you a certificate, you do not file the certificate with us, you file the certificate with yourself, essentially, and you, on your honor, report in the following year that you have complied or not complied with the rule, or whether you have an exemption, and we'll talk about exemptions a little bit later. And just so you know, the M in MCLE stands for minimum. I guess it also stands for mandatory, but minimum was the M that won the day before the judges.
There was objections to mandatory, so we said, okay, fine, minimum. We'll just call it minimum.
Okay, let's go to the next slide.
All right. I got it.
Okay. So compliance, who has to comply with MCLE? All Connecticut admitted attorneys, with some exceptions that we'll talk about, have to comply with the MCLE rule. If you are an active attorney practicing in the state of Connecticut, the presumption is that you have to comply with MCLE. The rule also applies to all authorized house counsel, that we sometimes refer to them as in-house counsel, typically lawyers who have been certified even though they don't belong to the Connecticut Bar and work for corporations. That's the typical in-house counsel situation. And the reason for that is that when attorneys apply to be certified as authorized house counsel, they agree to abide by all the rules and regulations that apply to Connecticut admitted attorneys, so they get caught up in the net that requires Connecticut admitted lawyers to comply with the MCLE rules. And are there exemptions? Yes, there are exemptions, and we will talk about them, I think, right now. So compliance exemptions. If you are, if you're a judge of the Superior Court, you do not have to comply with the rule, but judges is actually a very kind of misleading term because the rule is much broader than that. So if you happen to be a judge of the Superior Court or the Appellate Court or a justice of the Connecticut Supreme Court, you are exempt. If you are family support magistrate, you don't have to comply. You're exempt. If you are a federal judge of virtually any category, from a U.S. District Court judge to a federal court judge to an administrative law judge, you do not have to comply with the rule. So judges has a pretty broad spectrum. Most of you who are sitting here are probably not judges, so you will have to comply, but if you are planning on being appointed to be a judge, then you will be exempt, and you will be exempt for the calendar year in which you're appointed. That's one of our FAQs that we'll talk about later. Attorneys who are unfortunately disbarred or resigned or on inactive, which is disability status in Connecticut, also do not have to comply, as well as those lawyers who are retired. Now, retired is a term of art in Connecticut. It doesn't mean I'm still active, but I now live in Florida and golf every day. It actually means that you have applied for and been granted retirement status by the Statewide Grievance Committee. And there are two practice book sections in play there. One is section 2-55, which is revocable retirement, and the other is 2-55A, which is permanent retirement. If you're retired under either of those sections, formally retired, officially retired, I should say, you do not have to comply with the MCLE rule. If you are on active duty in the armed forces for more than 6 months, you do not have to comply with the rule. If anybody is in that situation here, they have probably run into that exemption when it comes time to pay for the client security fund fee. The exemption in the MCLE rule parrots the same exemption that applies for client security fund fee obligations. If the year in which an attorney is admitted or certified as house counsel is a year in which they do not have to comply with the MCLE rule, so a lawyer who is admitted in 2017 will not have to officially start complying with the rule until 2018. Same for attorneys who are certified as house counsel. Those rules just mirror each other. You do not have to comply with the rule in the year in which you are granted, but in every year thereafter. An interesting one is the next exemption, which kind of came into being between the draft of the rule and the adoption of the rule, is attorneys who earn less than $1,000 a year for the provision of legal services. So there are a lot of people whose licenses might be active, and those lawyers are presumptively required to comply with the rule, but they may, even though they are active, not really practice. And if they don't practice and earn at least $1,000 from the provision of legal services, they can take that exemption and not comply with the rule. But just in case anyone out there is wondering, $1,000 for the provision of legal services means the provision of legal services anywhere. So if you happen to be admitted in Connecticut and New York, and you don't practice in Connecticut, and you don't make $1,000 a year working in Connecticut, but you make $500,000 a year working in New York, you have to comply with the rule, because it's the provision of legal services anywhere, not just Connecticut. And finally, attorneys who get a temporary or permanent exemption from the statewide grievance committee. And I want to point out two things about that exemption. The words that the drafters used and the judges adopted are temporary and permanent, not partial and full. So these are temporal exemptions, they're not quantitative exemptions. By that I mean the committee can grant you a year off from taking CLE. The committee could say you never have to take CLE. But the committee can't say instead of 12 hours, you only have to take 6 hours, or you only have to take 4 hours this year and 6 hours the next. The committee doesn't have that authority under the rule. They can only grant you either a temporary exemption from having to take CLE or a permanent one for not taking CLE. And what that means, well, I imagine that we'll figure that out as we go along, but the committee has taken the position that, again, if you are active to practice law and you're not otherwise exempt from the rule, then presumptively you will take your MCLE and you won't be given an exemption.
But if you've very, very sick and you're not working, or if you've had an accident and you're unable to work and comply with that, then that would be the type of exemption that we were looking at, and hopefully not having someone worry about not making their MCLE requirement. If you've just decided you're going to play golf for 6 months and don't want to take the MCLE, that's probably not going to pass the grievance committee.
No, it won't.
Maybe running marathon, but
Yeah.
that's not going to make it. So it was really meant to take care of illness, some other emergency that comes along. And if it's something that's permanent, then obviously, but it's something that's serious.
Right. Think catastrophe, then we'll go from there. Okay, so how to comply with your MCLE obligations. The MCLE rule is pretty straightforward. You have to take 12 hours per year, and at least 2 hours of them must be in ethics or professionalism, which are synonymous terms. And that means 12 hours per year, let me give you an example. So there are people here that might be admitted in both Connecticut and, let's say, New York. And some other jurisdictions, say New York, say you have to take 24 credit hours over 2 years. Connecticut requires you to take 12 hours in a given year. And while we're going to be talking about a lot about reciprocity and your MCLA activities being in another state such as New York, applying to your obligation in Connecticut, you can't say I took 24 hours in the second year, in December of the second year in New York, and it applies 12 and 12 towards Connecticut. You've got to take 12 every year in Connecticut, notwithstanding the provisions of any other jurisdiction in which you are admitted. 2 hours must be in ethics or professionalism. Those are kind of, know it when you see it type seminars. Some seminars are dedicated solely to ethics and professionalism, from trust account management to updates on the rules, et cetera, et cetera. And you may find that CLE courses that you take have a portion of the CLE dedicated to ethics and professionalism. So you might be taking a course that in and of itself isn't on ethics and professionalism. It could be, say, on depositions. But there may be a portion of that CLE, they may talk about 15 minutes about how to act appropriately at a deposition, what are the rules that cover your conduct at a deposition, what happens if your client lies during a deposition, what are your obligations, that type of thing. And you're certainly able to apply that amount of time towards your ethics and professionalism requirement. So you may have 2 hours of CLE and have complied with 15 minutes of your ethics requirement. And that sort of segues into a next point, and that is there's no minimum amount of time that a CLE must run in Connecticut for it to count. And we'll talk about it probably a little bit more as we get into the PowerPoint a little bit more, but you can stack short CLE presentations to make your time. It doesn't matter if it's 5 minutes long or 5 hours long. You can, if you watch 12 5-minute MCLE videos or attend 12 5-minute long CLE seminars, you have an hour's worth of CLE.
And just so everybody understands, there's some rationale as to why we drafted it this way. One is that there's a lot of bar associations that run brown bag lunches, and we're going to talk more about that, where judges come and talk for 15 or 20 or 30 minutes, whatever it may be. And no one wanted to give up that nice thing that we still have in Connecticut, where a lot of the judges come and spend time, or that if you go to a section meeting or some other meeting and someone gets up and talks about for 30 minutes about a particular subject of the law, but that's not a certified New York CLE, that counts in Connecticut. And that was the whole point of being able to stack and build whatever type of CLE program you wanted to build. The second thing is, why are we doing 12 hours every year, is because the reporting, because we've got the reporting form that comes out that everybody has to register, it was easy to put a box on the registration. We get that every year at the beginning of January. So to skip and do 24 hours, then you'd have to figure out who gets it on which particular year. So we figured the easiest way was for everybody to fill out and check the box every year, once a year for 12 hours.
Okay, and then the next point is that you can always carry over up to 2 credit hours towards the next year. And you can carry over how much time we are here today to your next year's requirement. So if we're here for 2 hours today, congratulations, you have 2 hours already done for next year. You can carry it over to the 2017 requirement. I mean, my goal will always be to do 12 hours a year, and if I can carry over any of those next year sort of as a fail-safe, if I can't do my 12 the following year, I can only do 10, then that will be helpful. But if you take CLE now in 2016, it will apply up to 2 hours towards 2017's requirement, and then if you take overage next year, you can carry 2 hours to 2018, et cetera.
And that goes for any course in 2016. So if you know of someone that's taken a course in February of 2016 and they've got 2 hours they want to carry over, they can take those 2 hours and carry them over for 2017. So anything done in 2016, 2 hours carry.
2 hours carry, exactly. And we talked about this a little bit more. You can comply by complying with another jurisdiction's MCLE requirement. I don't mean to beat the New York dead horse, but New York is kind of a popular one. We've got questions about, we're going to get into about credit calculations if you're a member of the New York bar. But if you comply, if you're a member of another bar and you have been complying and you're active there and you've been complying with their CLE requirement for the last few years and going forward, when you take an approved CLE course in that other jurisdiction, it automatically applies in Connecticut. So if you take a 2-hour CLE class in New York, you've done essentially 2 hours of CLE in Connecticut. You can credit yourself to having done 2 hours of CLE in compliance with Connecticut's rule. To sum it up, you don't have to do your 24 hours over 2 years in New York and then another 12 hours in Connecticut for a total of 36. If you're in compliance with another state's CLE rules, those CLE classes will all have been approved by that jurisdiction, and they'll apply here in Connecticut, 1 for 1, just about. I mean, we'll talk about credit calculation. There's a little caveat to that you have to be careful about on actual instruction time, but we'll get into that nuance in a little bit. What I want you to take away from this latest point is that if you are a member of another bar and you are taking CLE for that bar's requirement, or just even if they don't have a requirement, you're taking CLE there and it's approved, you're taking CLE in Connecticut and you can count yourself, you can essentially count it twice. And finally, you can comply in just about any means you can possibly think of. You can do it in person, you can do it online, you can do it from a live event, you can do it from a pre-recorded event, you can do it from a streaming event, you can do it through self-study, you can do it by teaching, you can do it by publishing. There are myriad ways to comply with Connecticut's new MCLE rule, and if you look through how you can do it, it's pretty straightforward that the rule is very broad and meant to be as easy as possible to comply with in terms of the CLE activity you choose to do. And you can combine things. You can publish an article, go to an event. I mean, you don't have to dedicate yourself to one type of CLE compliance. They're all open to you. Do you have anything you wanted to add to that?
No, I mean, the object of the game was to try to just have the ability for someone wants to write an article, then you can write an article. If you are teaching a seminar, we've got a credit calculation where you teach a seminar. If you're a moderator, if you're on a panel, all of those things count. And the most important thing, and we're going to say this about 10 times, is those folks that are also in New York, that they have a 50-minute counts for 1 hour. We have a 1 hour counts for 1 hour. We'll say that about 10 times today.
Right.
So make sure, some states there's a lot of variety in a lot of the states, but we decided it was easier just to say 1 hour counts, so we're not fighting about what's 50 minutes and what do you do with the other 10. It's 1 hour for 1 hour.
Okay. So a lot of whether you're complying with the CLE requirement is up to the lawyer. Again, a lot of this is the honor system, and a lot of this requires you to study and know the rule. But the two catchphrases in the MCLE rule are, this rule is all about delivery and content. In other words, how or by what means are you getting your CLE, and what is offered in the CLE that you are taking. So you always have to ask yourself, who's delivering me the proposed CLE, and does the CLE meet the content requirements of the rules? And we'll talk about each of those in a little bit more detail. But what you must remember is that it's both delivery and content. It can't just be delivery or content. So one of the examples I was thinking of is that under our rule, the New Haven County Bar Association and other bar associations are automatically approved as deliverers of CLE. So you may say, I'm going to sign up for this activity sponsored by the New Haven County Bar Association. It's CLE because it's delivered by an approved deliverer of CLE. But that activity happens to be their golf outing. The golf outing doesn't meet the content requirements. I mean, I guess you might be there with a judge, you might talk about a case and credit yourself for the, let them win. But as a, thinking about it is that not every activity offered by an approved deliverer is going to count. Likewise, you may decide to engage in a self-study course where you are learning about the ethics of overbilling in tax law and think, well, that meets the content requirements of the rule. I'm learning something about the law, but it might be by listening to the audio tape of the firm on your way into work one day. John Grisham isn't an approved deliverer of CLE. So yeah, the content requirement sounds good, but the delivery requirements fail.
And the famous example used at the Rules Committee is watching My Cousin Vinny. So, you're right, and Joe's laughing about that because that was, so the fact of the matter is some great cross-examination that shows up in My Cousin Vinny. But it doesn't count for CLE in Connecticut, notwithstanding what anybody may think. So that's really, we're just talking about who delivers it and what's the content. And if the deliverer is, a legal provider of some sorts, and we'll go through the list, and the content is about the law, professionalism, ethics, something that's connected with practicing law, it's good.
When in doubt, best to ask us. Don't cozy up for a marathon of law and order and think that you're complying with the MCLE rule without asking us first. So, compliance. Let's talk about delivery. And I apologize for the length of this slide, but it's meant to convey to you that the drafters and the Rules Committee meant to take as much of the guesswork out of the question of, is the person who is delivering me the proposed CLE an appropriate provider? And so all bar associations, whether they're the Connecticut Bar Association or there's some specialty regional or cultural ethnic bar association, are automatically approved as deliverers of CLE in Connecticut. Private employers that put on CLE type events for their employees, and sometimes they'll put them on for other members of the bar or even members of the public, that counts as approved CLE providers. Government employers, the state's attorney's office, the attorney general's office, the public defender's office will often have or are required to have in-house training for their lawyers. They are approved CLE providers.
Right, so, and even if some of us in the room may be special public defenders, or you do some work for the state, and I do some work for the State Department of Education, and they run a one-day, usually half-a-day seminar for all the attorneys that do work for them, that counts as CLE, because they go over all the new cases and all the new procedures for hearing cases.
Basically, any course you take sponsored by the court, this court or any court, constitutes a CLE, which is one of the reasons why your attendance here counts as CLE towards next year, if you want to credit yourself for whatever time we're here today. CLE providers with pre-approved courses in other jurisdictions. We've been hammering this sort of reciprocity thing all day, but if you take a CLE course that's been approved in another jurisdiction by that jurisdiction's approving entity, and it'll probably say it on the advertisement for it, you're complying with Connecticut's CLE rule, and you can count it towards your CLE requirement here in Connecticut.
So a couple of those, PLI, we all get the brochures. All those brochures that are approved by New York or Massachusetts or something, Mass doesn't have, but any of the other New England states, any state, that's approved for Connecticut, because it's already been approved by some other bar entity.
Right, and finally, this big catch-all one, any other nonprofit or for-profit legal education providers, including law schools and other appropriate continuing legal education providers. So, like Fred said, you probably get advertisements quite often for, usually, let's put it honestly, for-profit continuing legal education providers. You sign up for one of their classes, it meets the content requirements, which I'm sure most of these approved providers do. You are complying with Connecticut's CLE requirement. The takeaway from this is that the commission and the judicial branch is not in the business under this rule of approving CLE providers. We're not doing that. We're not approving courses, and we're not approving providers. The rule is incredibly broad. It requires the lawyer to understand the rule and apply not only their knowledge of the rule, but really some good old-fashioned common sense to determine whether the course being offered to you is from an approved CLE providers. And this rule really covers just about every possible CLE providers as we kind of understand CLE providers to be, or educators to be, they are covered here.
So for a couple of other examples, the Bar Foundation puts on a couple, 4 or 5 programs during the year. Quinnipiac does, UConn does, PACE does. NITA, the National Institute of Trial Advocacy, has online all of their courses that they gave the year before. They have them online for free. And so those all count. So in other words, just what Michael said, very, very broad, but using a little common sense really is going to answer the question as to whether it counts or not.
I mean, I don't know how many are UConn law graduates, but as an alumnus, I regularly sent emails about things I can attend after after hours. And, you know, the cocktail receptions probably aren't CLE, even if I'd like them to be. But, you know, UConn's an automatic provider. So a lot of those things that they're going to advertise for you to come to may very well count towards your CLE requirements. And I'm sure every law school sends out their alumni requests to come. I mean, it might be just a guise to try to get money from you, but they also are offering you something in terms of CLE. And again, this rule is very broad to cover those situations and to cover a lot of potential deliverers of MCLE. Do you have anything else to say about that one? Nope. Okay. So what are some examples? And we talked about this, and Fred had touched upon some other ones that might not immediately come to mind. Obviously, any bar association CLE, state, local, regional, ethnic, cultural bar association, anyone putting on CLE is automatically approved. In-house programs, we talked about that. Fred talked about brown bag luncheons. It's a popular small niche thing that a lot of bar associations put on. They might get, I don't know, 20 or 25 people together for a brown bag lunch where maybe a judge comes and talks for a while, or they go over some new cases or things affecting the local bar. Those will count as approved CLE. Law school courses and presentations. If you audit a law school class or go to one of these presentations, like I just talked about, they'll count. Law firm presentations. Again, we talked about this. Law firms, I used to regularly get, I still occasionally do, we'll get a brochure from one of the big firms in Hartford putting on a presentation about some new aspect of the law. How does this decision affect you? The Supreme Court decision affect you? You sign up and go to that big firm event. Doesn't matter if you go to that firm or not. That would count as CLE in Connecticut. Government-sponsored employee training programs. We talked a little bit about that also, like the Attorney General's office, the State's Attorney's office, et cetera, et cetera. We've been talking about it a little bit in judicial also. And if bank and title presentations, you may get, if you're doing closing work, you may be getting offers from either banks or title companies about new rules and regulations, about closing practices. They seem to be changing a lot and all the time and getting more complicated. You go to one of their seminars, you're complying with CLE, and obviously private CLE vendors, either for-profit or nonprofit, as we talked about a minute ago.
And the one question we've been getting a lot about is if the family law section has a meeting on Wednesday night and Judge Collin comes to talk for a half an hour about what he expects, let's say in Stanford in the domestic court, and he talks for 20 minutes or 30 minutes, even though that's not certified, it's not approved for New York, it's good for Connecticut. So if the workers' comp section is meeting, labor section is meeting, you know, litigation section I know is meeting this week at the Quinnipiac Club. That time when that person is speaking and there is education that is going on, if it's 20 minutes or if it's 15 or 30 minutes, that counts. And you just record that on the sheet. You say where it was, what it was. The cocktail hour, the dinner, and the drinks after do not count. All right, so it's really, it's the honor system, and that's really what we're looking to have here, is really the honor system.
And we'll talk about it later, but both at the end of your packet and online, there will be a form, not required, but there for you to track your CLE for a given year, including carryover credits. It's already up on the website, and it'll be there for you to use.
What about something like a webinar that's provided by Thomson Reuters about, for instance, discovered best practices?
Right, that is the next thing on the list. So, and the question was, what about webinars, but Thomson Reuters or any type of webinar? And the answer is almost all webinars that are related to the law and that the content is appropriate are going to count for CLE for us. So we're going to, it's the next slide up?
Yeah, so, well, actually, you know, just at the end, we're going to have a question and answer period at the end, so let's see if we can just hold them till then. I don't know, I probably only have 10 more slides to go or so. So we talked about traditional CLE in the last slide, in the slide before that. In other words, I go to the course and I listen to someone speak and I've gotten CLE. Well, what if I don't want to go to the course? I want to do something else. I don't want to attend in person. I want to take my CLE a different way. Well, the rule calls that self-study, and it's treated with the same it's with the same rights and privileges as the in-person one. Again, the rule is meant to make it as easy for the lawyer in Connecticut to comply as possible. So self-study basically means getting your CLE by not showing up in person, but getting it through some other means. And, well, okay, how do I know that what I'm getting is okay? Well, if it's provided to you by one of those CLE providers that we talked about who's automatically approved, the bar associations, the in-house programs, the for-profit, non-profit CLE providers, then you know what you're getting for self-study is okay, as long as, again, it meets the content requirements, which most of these do and we'll go over. And all means of it are allowed. So you can read materials, you can view things online, you can listen to podcasts if there's such a thing for CLE. You can watch a streaming course, you can watch an online course. If you have a friend who wanted to attend today's seminar and could not, and they want to watch it 2 weeks from now, well, that would be self-study by watching an online presentation, and they will get the exact same credit that you will get for sitting here today. So you're doing it the old-fashioned way. You're sitting here and listening to Fred and I talk. People who are going to watch it online in a couple of weeks, they're getting it the self-study way. They're going online and they're getting it themselves. And again, it covers just about every way you can think of. As long as the delivery vehicle is approved and that the content is approved, we haven't gone over content yet, but we will, then what you are watching online, what you're reading about, what you're listening to, is considered CLE just the same as if you were sitting in a seat and watching someone give it to you live.
So a lot of folks, when we were talking about this, said, well, you know, I can't afford to take CLE, it's going to cost me more money. Well, one of the things that's changed in the last 5 years is the amount of free CLE that is online, that is quality CLE, that is really good material, not just sort of, you know, and that has really changed. So if you go online, for example, the National Institute of Trial Advocacy has a significant amount of free CLE, which is really high quality. They charge a fortune for it the year that it comes out, and then they're offering it now for free the year after. So the American Bar Association has free CLE. The Connecticut Bar Association is going to post all of its older seminars, a year or so old, online for free for all of its members. I know that I have a significant list of what's free CLE. If you go on iTunes nowadays and you take a look under law, you'll be amazed to see under iTunes Harvard law courses, Stanford law courses, and short seminars that are actually online on iTunes that are significant content and free. So that's the difference between where we were a few years ago and where we are now. And cost for the branch for administering it and cost for the lawyer for taking it was really taken into consideration. That's why we had the self-study portion that was added.
Okay. And then our last slide on the delivery portion of the rule is what counts as MCLE. So we've been talking about attending a CLE class in person. We've talked about maybe not attending a class in person, but viewing it online or purchasing a tape or something like that. But there are other ways that you can comply with your CLE requirement. One is by publishing an article in a legal publication. So your article might not be like a movie review or something like that. But if the article you publish has the primary goal, the enhancement or competence in the legal profession, so sort of think about a law review article as we all know and love, or even an article for your local bar association's newsletter or something like that, that has the goal of enhancing the legal profession. Well, the time you spend preparing that article counts as CLE. If you teach a legal seminar, like I'm and Fred are teaching this seminar today, or you participate on a panel as either a speaker or a moderator, that time that you're doing that type of work counts as CLE. And when we talk about credit calculation, even the time you take to prepare for that course counts towards your CLE also. The one caveat to remember there, and we'll go over again, is that you can only teach that seminar, or you can only get credit for teaching that seminar once in a given year. Fred and I will probably teach this seminar 10 times by the end of the year.
So I'm done for 10 years.
Yeah, but we can only count it once for 2 hours. And if we do the same thing next year, the first time we teach it, that counts. Every time after that doesn't count until the next calendar year. So you can teach a seminar, but you only get credit for it 1 year. Now, if you happen to be a full-time, part-time, or adjunct faculty member, then you get credit for as much time as you're teaching. You get an hour-for-hour basis. So if you're a full-time faculty member at a law school, an accredited law school, you are, by nature of your job, almost exempt from the MCLE requirement because you're full-time serving as a faculty member teaching at the school will certainly be more than 12 hours in a calendar year. At least I hope so. And the same for part-time or adjunct faculty members. Every hour that you spend teaching in that school counts as an hour of CLE in Connecticut. So those are other ways that you can comply with the rule other than sitting for a course, watching a course online, as we've talked about in the other slides. You can publish an article, you can serve as a teacher, and you can teach legal seminars.
So I know one of the complaints that we've heard from some folks is about watching webinars. Well, how do we know that anybody's going to watch the webinar? They just turn it on, go in the next room, cook dinner, eat dinner, and the webinar is sort of rolling along. You know something? If you want to write down that you watched the webinar, you've watched the webinar. If you, we're not going to play police. So hopefully, because lawyers, have a little bit of hopefully ethics. Should I say ethics?
Yeah.
Ethics. That they will watch the webinar. And if they do have to eat dinner, they'll turn it off. They'll go eat dinner. They'll come back and they'll turn it back on. So that's what we're hoping. If it doesn't work out that way, I guess we'll find out as time goes on. But I'm hoping that it's not going to be necessary for anybody to hire staff to run around and watch people watch webinars. That's really what we were trying to avoid doing. And New York has 2 folks that are full-time employees that read the materials. And they pay them a ton of money to read the materials for CLEs. And most of the time they find the materials are terrific. That's not what we wanted to do in Connecticut with our limited funds that we've got. So. All right, what counts?
All right, what counts as MCLE? So we were talking about delivery vehicles, who can give it to you or how can you do it. Now let's talk about content. So why isn't the New Haven County Bar Association's golf outing, why does the golf outing not meet the content requirements? Well, Practice Book Section 2-27A, subsection C, subsection 6 is the content part of the rule. And so when you are having an approved deliverer give you CLE, the content requirement requires the proposed CLE to have significant intellectual or practical content designed to increase or maintain the attorney's professional competence and skills as a lawyer, constitute an organized program of learning dealing with matters directly related to legal subjects in the legal profession, and, not or, be conducted by an individual or group qualified by practical or academic experience. I don't know if anyone here is admitted to the Florida bar, but these first 3 prongs are taken verbatim from the Florida rule.
Yes, we stole it from
We
Florida.
sold them. We essentially.
I readily admit that.
Yes, you do. So these are the content ones, and is it a lot of words? Yeah, but I mean, I think when you read them, you're like, well, that just makes sense, right? I mean, it's supposed to make me smarter. It's supposed to be something that we recognize as CLE, and it should be given to us by someone who knows what they're talking about, right? So that is the content requirement. So when you're looking at a proposed course, almost always, if it's one of these approved delivery mechanism and it calls itself CLE, it's going to meet this content rule. But when you're in sort of a gray area and you're like, okay, it's offered by someone I recognized as approved CLE provider, but I'm not really sure about this course, well, reread this rule and ask yourself, does it pass the smell test with me? Is it kind of in a gray area? And if you're still not sure, then you should probably ask the MCLE Commission, do you think that this complies? Because one of the MCLE Commission's requirement is to try to make this rule understandable to the bar and help the bar comply with it. We have 11 pages of FAQs that we've prepared that are actually part of your materials today. that we hope will answer a lot of questions. But again, this content thing, I mean, I've read it a lot of times, and I've always been like, this seems to be a pretty common sense three-part factor about whether what I'm considering CLE really is CLE in the traditional sense.
The one part that we did not steal from Florida is the written materials part. And we did that very much on purpose. So if you read this and then you go look at some of the other bar associations or states' rules, it has to have 6 pages or so many pages of materials for you to take away with you. And we didn't want to do that because of some of the brown bag lunches where judges may come, and that's something that still is worthy to have happen. And some of the section meetings may not have materials. So, and really, who wants to sit there and check the materials and make a determination whether they're appropriate or not? So that part that many other states have with materials, we don't have in Connecticut.
Right, and just the final follow-up on that is, as I mentioned, neither the MCLE Commission nor the judicial branch approves providers. We also don't approve content. So if you have a proposed MCLE and you're like, here are the materials, there are materials, does this comply? We don't want them. This is something that you should look at, and again, on the honor system, and then as an officer of the court, determine whether what you're getting and what you're counting as CLE meets the delivery and content requirements of the rule. You don't need to send it to us. We'll rely on your determination. Okay. And that sort of segues into this next slide. There isn't any formal approval process for the course to be considered compliant with the rule. Again, one of the goals behind the rule was not to sort of expand the regulatory bureaucracy in this area. There's plenty of regulatory things. We come knocking on your door every January for your registration and every May for your client security fund fee, and then the DRS knocks on your door for $600 and something every December. The idea here wasn't to create a larger bureaucracy. It was to try to get people to comply with the rule as easily as possible. And one of those ways was, we're not going to sit there and be in the business of looking over your shoulder to determine whether what you took complies with the rule. That's something that we expect you to do by understanding today's seminar, going on, reading the FAQs, and understanding the rule. Again, and we've talked about this a million times already today, if it's approved somewhere else, it's approved in Connecticut. If you're a member of the Guam Bar Association and it's approved in that territory, thousands of miles away, it's approved in Connecticut. There's no pre-approval process. You don't have to ask us if it's okay to take this course and count it to CLE. That's up to you. But again, and I said this, and I think Fred's echoed it, when in doubt, ask. There's a dedicated MCLE inbox that we'll talk about when we talk about contacting us with questions. And there it is. When in doubt, should have read the slide before I talked about it. When in doubt, contact the MCLE Commission. There's a dedicated website. It goes to my office. We screen those emails and send them to the MCLE Commission as necessary. So if you're desperately confused and the FAQs don't help you, send the MCLE Commission an email and ask. It's better to ask than to kind of be walking around in the dark on this. The only thing I ask, and I sort of spread the word for us, is before you ask, just take 10 minutes and read the FAQs. The MCLE Commission took a lot of time and went into a lot of effort to prepare, I think it's 11 pages of FAQs that are currently online and are part of your materials today. We have tried to answer every question, and we know that we haven't answered every question because you just don't know sometimes until the rule gets up and running. But before you ask, take a moment to look through the FAQs and see if they answer a question, or at least talk about the area that you want to know, so that if you have to ask the MCLE Commission, it can be as informed a question as possible. All right, credit calculation. All right. The language of the rule says that credit for a continuing legal education course, no matter how it's delivered, is based on the actual instruction time. So that includes the lecture like Fred and I are doing today, the question and answer session, if there's a question and answer session afterwards, if there were a panel here of lawyers to talk about the CLE rule, in self-studying things, if you're reading materials in addition to watching something or reading something or listening to something, those all count 1 minute per minute based upon the actual time that you're doing it. So we go back to New York. So New York has a rule that says you get 1 hour of CLE credit for a 50-minute lecture. So 50 minutes in New York counts as 1 credit hour. So what do we do with that in Connecticut? Because we've told you that if you take a course that's approved in New York, it's automatically considered CLE in Connecticut. Well, this is the downside, I suppose, of the rule. That 50-minute course in New York may give you an hour there, but it only gives you 50 minutes here because your actual instruction time was only 50 minutes. So if you sign up for a 2-hour class with the CBA, and that includes a 15-minute break, your actual instruction time is 1 hour and 45 minutes. So it's just something to be careful of when you're crediting yourself for your CLE. The CLE has to be based on the actual instruction time, and I guarantee you that this will be an area that we are not monitoring to bother you, but monitoring to see how it works out for us in terms of this grand MCLE experiment that we're starting in Connecticut in January. It's just one thing to really pay attention to, that breaks don't count towards your requirement.
And there's other states that go 1 hour. It wasn't universal if 50 minutes was it just happens to be that the state next to us is New York is 50 minutes. So we were trying to stay as simple as possible. So if you do 15 minutes counts. If it's a 20-minute lecture at a section meeting, you can, as we said, you can stack, and we've got that in our materials. So it's 1 for 1.
Yeah, and that's the next area, the stacking one, about no minimum time for CLE. That's sort of the suite that goes with the bidder of actual instruction time. Is some states require you to attend a CLE class for a minimum amount of time before it can count as CLE, not Connecticut. Connecticut, you can watch 1 minute of a CLE, and you have 1 minute towards your 12-hour goal. And so
Then there's a good question about content, whether 1
Well,
minute
1
counts
minute,
for content.
right, like just, good afternoon, and you turn it off, and you count yourself for a minute. But, I mean, it's hyperbole to prove a point, and that is in Connecticut, whether it's, a minute long or 10 hours long, if it's CLE, and you can aggregate or stack those smaller CLE requirements to get to your greater 12-hour goal. Not every state allows that. Connecticut does. And finally, we've talked about this a few minutes ago, and we'll get to it in a bit, but there is actually a credit calculation form that the CLE Commission has adopted that's on the Judicial Branch website. Again, it's not a required form, it's just a useful form. It's helpful. It allows you to track your CLE for a given year, make sure that, I took all these courses, I can't remember what I took and when. Well, if you write them down on the form, it's a fillable PDF, keep it saved. You'll be able to keep track on a year-by-year basis. And it has an area for carryover credits. I think it's pretty useful. I plan to use it. I know Fred does. And it'll be there for you. Okay. There is, when we talked about teaching seminars, we talked about the fact that if you teach a seminar, like Fred and I are teaching this one today, we can count the instruction time that we are delivering this course to you on a minute-per-minute basis. The only thing to remember about that is there is one slight difference in credit calculation for when you're teaching a seminar, and that is that the preparation for that seminar does not count 1 for 1. It counts 2 for 1. So every 2 hours that you take preparing for the course that you give counts as 1 hour of CLE. When you stand up and start presenting it, then it's a 1 for 1 basis. But preparing it is a 2 for 1 basis. And I don't know that anybody would spend more than 6 hours preparing a CLE seminar and delivering it. But if you spend 8 hours doing it, there's a 6-hour cap. So you can't get more than 6 hours for any one CLE presentation that you prepare and deliver in a given year. If you prepare and deliver it again the next year, you can take that amount of time again, but you can never take more than 6 hours for delivering any one CLE presentation on behalf of a bar association or something else. And again, we talked about this, you can't get credit for teaching the same course twice in a given calendar year. You can get credit for it again the next year, you just can't get it more than once in any one given calendar year. You have any comments on that? No? Okay. And then, again, if you're a full-time faculty member, you're automatically credited. We assume you're going to spend more than 12 hours teaching. And part-time and adjunct, you get a one-to-one basis. So every hour you spend teaching is an hour of CLE for credit. Oops, I shoot that twice.
Yeah.
And then carryover rules, every year you can carry over up to 2 hours of excess CLE to the next year. We talked about this, the time you spend here today with us, we're already knocking on the door of an hour, can be carried over to next year's requirement. The 2-hour carryover credit applies to any voluntarily taken credit in 2017. If you know any new bar members and they're having questions about, I think there's a swearing-in ceremony that just happened, I think. And those new bar admittees and the ones that were admitted earlier in the year from the February bar, if they've taken any CLE, if you are one of those people or know somebody who is, and you've already voluntarily taken CLE for this year, well, you didn't have to take CLE in 2016 if you were admitted to the bar. That's one of the exemptions. But you'll have to start taking it next year, and if you've taken at least 2 hours, or you've taken 2 hours, you can carry that over to your 2017 requirements. And yes, of course, this seminar counts as CLE, whether you're sitting here today or if you end up watching it later online or know somebody who is. I'm sort of saying that for the benefit of the taping. If you're watching this online and didn't make the CLE seminar, it counts as carryover credit to next year. Reporting. Reporting, so some states have elaborate means of reporting. Every time you take a course, you send something in, there's an online check and audit process. Everything has to be approved before you do it. That's not how Connecticut does it. In its simplest form, beginning in 2018, compliance with CLE will be by a checkbox on your attorney registration form. So you won't see it in 2017, of course, because it isn't required in 2016. But your 2017 compliance will be reported on your 2018 form, and going forward, it'll be the same thing. In 2019, you'll check off that you complied with 2018's requirement. It's basically, again, a checkbox. You'll check, yes, I complied, no, I did not comply, or I have an exemption. And for anybody who's ever filled out an exemption on the Department of Revenue Services occupational tax form like I do every year, you still have to, as a state employee, I don't have to pay the tax, but I still have to file the tax return and take the exemption. Same thing in Connecticut. You may be exempt from the MCLE rule, but you're going to have to check off why when you register. And part of that is we sort of want to collect stats on what exemptions people are taking and see what's common out there. And it also goes to sort of the compliance issues. We want to make sure that, people are, checking off the proper exemption, et cetera. I suppose the best thing not to do is just not register. I haven't done my MCLE. I'm not going to register. What are you going to do about it? Well, the failure to register is misconduct. And one of the things that we're sort of going to be on the lookout starting in 2018 is how many people register. So if we see a huge drop-off in registrations as compared to the following years, you'll likely get a pleasant email from us reminding you that you haven't registered and that you do need to register. And when you do register, you have to sort of certify that everything you're saying on that registration form is true. I probably shouldn't have to say that. So you'll need to check off that you've complied or you're exempt from the MCLE, or that you've complied with the MCLE rule, or that you're exempt from it, or that you haven't complied.
And registration, everybody knows, registration doesn't cost any money.
No.
It's free. I mean, it's just have to register as an attorney in the state of Connecticut. So hopefully that will not be a big obligation.
Right.
We hope.
Hopefully, right? So, and finally, just for reporting requirements, you have to maintain records that you've complied with the CLE requirements for 7 years. I'm going to have a file in my office that says MCLE, and I'm going to keep my MCLE credit calculation form and any other proof that I've taken CLE in that file. And if, I don't know, I guess I come knocking asking for proof of compliance, I'll have it to report to the grievance committee, and we'll go from there. So, all right, oversight and regulation. So there are two parties involved in oversight and regulation. The first is the MCLE Commission, the newly formed commission, and the second is the statewide grievance committee, which has been around a while. So the MCLE Commission is 4 judges and 4 attorneys. Fred is the co-chair of the MCLE Commission. Judge Solomon, the deputy chief court administrator, is the co-chair with Fred. The commission has its own website where you can read the agenda and minutes of MCLE meetings. Typically, the commission meets on the first Thursday of the month, although in December we're going to meet on the second Thursday of the month. The meetings are public. The agendas are always posted. The minutes are always posted thereafter. It's usually by conference call, so if you want to attend the meeting, which are non-participatory by the public, but if you want to attend the meeting, usually there'll be a place at 100 Washington Street where you can go and listen to the meeting if that's your thing. Again, you can read the minutes from previous meetings. The charge of the commission, I won't read it to you. I've quoted it below. But you know, the takeaway from that is the commission is there to help you as a lawyer comply with the rule. They have already published a long list of frequently asked questions. I will bet a bit that we will be adding to those FAQs from time to time. We may be even modifying those FAQs from time to time. But those FAQs are meant to sort of give you the lay of the land on how to comply with the rule. To prepare documents to help the bar, they've already done that. The MCLE Commission has already prepared that credit calculation log. And really, it's to help you. So again, if you kind of, after everything, after listening to the seminar, reading the FAQs, looking at the forums, you're still in the dark about a particular MCLE question, send the commission an email, mcle@jud.ct.gov. And if it's an easy question, we'll answer it right away. If it's a hard question, we'll put it on the commission's agenda and spread the word.
Also, if you want to look at all of these materials, they're on the judicial website. There's a tab that says attorneys. You click on that tab, and then there's an MCLE link. And all the materials, the FAQs, the forms, the rule, everything, the agenda, the meetings, all of that stuff is on. And it's right on the front page of the judicial website, where it just says attorneys. So,
And
easy to find.
And well, that's this slide shows us the commission's website, which if you may or may not want to bookmark. Just so you know, that isn't the actual, that's a separate website from the actual MCLE website, which has the rule, the FAQs, that have the registration for today's event on it. That web link is later in this presentation. And it's not a bad idea to think about bookmarking that link somewhere where you'll have it. I mean, this is a new rule. You may have questions about it. It's a good website to refer back to from time to time. And again, when you're in doubt, you don't want to be looking around like, what was that email address they told us? You know, if you have that website bookmarked, you will probably save yourself some headaches. These under the rule are to enforce it. Because not only is it misconduct not to register, as we mentioned a few minutes ago, but it's misconduct not to comply with this rule. So violation of this section shall constitute misconduct is a subsection of the rule. There is a 60-day provision in the rule. So if someone fails to comply with the rule out of, let's say, nonfeasance as opposed to malfeasance, there's sort of a 60-day extension that we can give a member of the bar to finish their MCLE for the previous year. But shouldn't be considered a grace period. Our FAQs go to great length to discuss that with you, is that lawyers before they're disciplined are supposed to be given 60 days to comply with the MCLE unless the failure to comply was willful. But it's not a grace period like, oh, I really have until the end of February the next year to comply with this year's CLE requirements. So listen, the first year we're sort of hoping that the bar, you know, reads the rule, and whether they love the new rule, are neutral on the new rule, or are against the new rule, that they comply with the new rule, because that's what we're all required to do, right? We sort of signed up for the whole, become a lawyer thing in Connecticut. We agreed that we were going to follow the rules. And this is a new rule. And what we hope to see is that lawyers comply with the rule, they comply with the registration requirements, and that they become, become part of it. But because always in the background is that I guess if what we see is lawyers aren't registering, aren't complying with the rule, then the grievance committee, which has plenty of work, I assure you, will have to probably think about steps to try to enforce the rule a little bit more. But I don't want the takeaway here that January 1, 2019, we're going to be kicking down doors asking for you to show your compliance. That's not how we run things in East Hartford, and that's not how we're going to run things going forward. But you have to be part of that solution too. You got to meet us halfway, whether you like it or not, and comply with the rule, do your registration, et cetera. Okay? And then this kind of sums it up. It's a good citizen's responsibility to question authority, not my authority, of course. So, again, to sort of finish where we started, the MCLE rule in Connecticut has had a long history. This is the land of steady habits. It hasn't been an easy journey to get an MCLE rule in Connecticut, but here it is. It's here now, effective January 1st. It's here for all of us. I'm not exempt because I'm a state employee. Brett isn't exempt because he's the co-chair of the commission. We all have to be. We're all sort of part of it. And as I said at the Hartford the other day, now is not the time to have your throw moment and decide you're not going to do it because you might not like the rule. I assume a lot of you are here today because you're interested in the new rule and want to learn how to comply with it. And so compliance is sort of a two-way street. We aren't going to be knocking on your door demanding that you show us. We don't plan unless you're grieved or audited to look at those records. But again, we just ask the bar to meet us on this obligation and comply with the rule. So, more information. The first is the MCLE website, which I suggested that you bookmark. It's right there. That MCLE website has forms, FAQs. It's a simple, straightforward website that we can add to as we need to. There are two forms at the end of your booklet. One is the credit calculation log, which is currently available. The next one is the request for exemption, temporary or permanent, that isn't available yet. We're still in the approval process of it. That will be available later in the year if somebody wants to request a temporary or permanent exemption. Again, if you need to contact the MCLE with an MCLE commission question, that's the website, mcle@jud.ct.gov. And if you have an enforcement question or a question about how to register properly, which is part of the grievance committee's thing, that won't be a question you'll have until probably this time next year, but you always can email us at statewide.grievance@jud.ct.gov, and we get back to you, I promise. We answer our emails. So it's always easier to email us with a question than to call, especially if it's a question that I have to forward to the commission to answer. You don't want me paraphrasing what you said in a phone call. I'll always ask you to follow it up with an email so I have something in writing. So it's just easier to start with an email. So,
All right, questions?
questions.
So we have to repeat the questions because of the video, all right? You want to stand, maybe make it easier to hear.
There's stacking of ethics and substance. So for example, if you go to a CLE and it's a 1-hour course and you have 15 minutes of ethics, you have, and I know the 15 minutes would go to your 2 hours, but you still count the full hour as your part of your CLE.
No, it's 1 hour. So it's 15 minutes towards the 2 hours and 45 minutes towards the 10 hours.
Okay, that's what I meant. And the second is, you talked about preparation for seminars, but what about teaching? The preparation for teaching the class as a faculty member, is that 2-to-1 or is that 1-to-1?
I think there's an exemption for full-time faculty altogether.
Or the adjunct?
That's correct. So adjunct, it's a good question.
So, and just again, to repeat them, the first question was,
For teaching.
if you take an hour-long CLE seminar, and 15 minutes is devoted to ethics. How do you calculate that? Is that really like an hour and 15 minutes, or is it just an hour? And the answer is it's just an hour. All of it goes towards that 1 hour all goes to your 12-hour requirements, and the 2 hours that you need, 15 minutes of it goes towards your professionalism requirement, but you can't count them twice. You can't say, I went to an hour long, and then I also did 15 minutes of legal ethics. And then the second one was if you teach, do you teach at a law school, or was it teaching a seminar?
No, it's an adjunct.
Adjunct professor. Right, that's only teaching, that's teaching a one course and then preps for that course. That's what you're, that's what you're,
I want to know if it's one-to-one or is it two-to-one for preparation? Because you have, if you look at your.
right, it's 2-to-1 for seminars and for,
Seminar,
yeah.
that's not a seminar, that's.
Correct.
faculty.
Good question. Good question.
It only says one-to-one, it doesn't give you credit for credit time.
Yeah, I mean, so the second question was, if you're an adjunct faculty member, well, teaching is a one-to-one, what about preparing to teach the class? That's a question, that's a good question. I suspect that if just looking under the adjunct faculty rule, it seems to say that it would count one-to-one. So a professor looking over his or her notes as a full-time faculty member wouldn't have to worry about this, obviously, because they'd have so much surplusage every year. But the adjunct may say, I teach 10 hours a year in classroom and I prepare for 2 hours a year. Do I get 12 hours or do I have 11 hours because of the 2-to-1 credit? The rule on the 2-to-1 says, I believe, says it's 2 hours of preparation from one when you are teaching a seminar.
Right, doesn't say that
Which
for,
is different than the adjunct one.
Right.
It
Good
would
point.
seem to me that it would be one-to-one.
But it says, it does say classroom instruction, so that's a good point. I'm going to add that to my list of things that we may need to clean up.
Yeah.
Yes? Yes, sir.
Could you please walk us through the process, nuts and bolts wise? So 2017, we start the program, we start taking the courses, et cetera,
Right.
and we keep track of that.
Right.
And then in 2018, that's when you're looking for registration,
Right,
correct?
right.
And are you providing the forms on the website? or-
No, the registration is the registration that you all get every year in January. It'll just have a little box at the bottom.
Right, so the question was if we could walk
Right.
the participants through the process about when you take the courses and how you show compliance and whether the compliance forms are available online. And as Fred mentioned, the compliance form is the registration form that you have all known and loved since 1990. So registration is done online every year. You sign in through e-services, you pick your registration, you view the course, you view your registration form online, you certify, you make any changes, you certify and submit it. In 2018, that form will have an additional area on it. It's not on there now and it won't be there in 2017, but in 2018, there'll be a separate area that asks you to check off that you complied with CLE or that you had an exemption.
So that constitutes both exemption and year-by-year compliance.
Yes, so it does, the question is, does that count as exemptions and year-by-year compliance? Every single year, you will certify that in the previous year, you complied with the MCLE requirement or that you were exempt, and if you were exempt, what exemption you fell under.
Right.
Desi?
Hi, Mike. A couple of questions.
Thank you.
I have a colleague who's putting together a symposium, and this is mostly lawyers regarding land use and alternative dispute resolution. It's not technically a for-profit or a nonprofit organization. They're loosely affiliated, but they do put on an educational seminar, and it's an all-day seminar, and they've been doing it for years. They would like to advertise that for CLE credit, and I understand that statewide grievance committee is going to be giving some language that providers or groups can be using. Do we know when that's going to be ready?
Well, the disclaimers issue was on the commission's agenda for November, and they've approved some language that once it's, so we put their language, they made some modifications. It'll be on the December agenda for final approval. Then it probably will be available on the MCLE website. So the question was, is the question, Desi, just about the disclaimer issue or whether?
So, yes, it's a couple of things. Can they advertise that it's suitable for CLE credits? Because essentially it does meet the content and possibly the provider as an other appropriate continuing legal education provider. They just don't know how, because a lot of it now is going to be, hey, we put this symposium on every year.
Right.
We have all these great lawyers and
So-
judges that come to speak. How do we get now more people to come now that we have CLE? We can say that we'll qualify, well, they can't say qualify, but suitable for CLE credits. Can they say that?
Yes. So it's up to them to make sure that it complies with the rules. So they have to look at the content and they have to look at the delivery. And they can put on there that in their opinion, it complies with and is suitable for MCLE for Connecticut because it complies with Rule 2-27A, I think it was.
Okay, and then my other question is, for those attorneys who participate in something called In Support, and that is a monthly meeting of
Right.
lawyers and judges.
Right.
Where we get together and we put together educational seminars once a month, that would seem to comply.
Yes,
with
absolutely.
the rule as well.
Yes, but not the dinner,
Not the dinner,
but
not
the
the
talk.
cocktail hour.
That's
but
correct.
the preparation.
Just like the section meeting. So Inns of
Okay.
Court, then that came up during the hearings, whether Inns of Court would and other, ABOTA, if ABOTA has a dinner and then, but they have a speaker at that dinner, that would work, just for the speaker, not for the dinner.
Yes, thank you.
First of all, Mike and Fred, great presentation. I hope you repeat that to the camera so the rest of the folks can hear that. Thank you. My question is, you mentioned brown bag judges that might be analogous to a law firm putting kind of its lawyers into a room apropos of written materials. So the brown bag, you don't typically have written materials. Are written materials a prerequisite for qualifying the CLE credits?
And the question is, are written materials a prerequisite for approval of a CLE course? And the answer is no.
No.
Not in Connecticut.
No.
Sir?
Would an article for the Connecticut Law Tribune or the Connecticut Bar Association magazine be considered if it's a substantive nature?
Yes.
The question is if I'm sorry, an
Yeah.
article for the Connecticut Law Tribune or similar periodical, would that constitute, if it is of a substantive nature? Absolutely, yes.
Right, the Law Tribune or the Connecticut Lawyer, there's a bunch of different magazines. The ABA Journal, that would count. Does not have to be a law review.
What about teaching legal classes to non-lawyers? Does that count?
So you got to do a little bit more than just say legal classes. Again, you've got to, so what, teaching legal classes to non-lawyers is the question. So it's a lawyer that's teaching that class, and what's the content of that class?
It would be something about law, for example, teaching an ABA class to human resources, or teaching medical malpractice to our medical department.
So it sounds like it would be an in-house type situation? Okay, because if you're teaching at a school, it has to be at an accredited law school. So the person teaching business law at an undergraduate level probably isn't going to get the credit, at least under the full-time faculty member. But if you come up with a presentation, let's say on medical malpractice, that you're going to be teaching your paralegals at a firm, that would seem to me to comply with the delivery and content requirements. So when Fred and I were at the Hartford last week, people were asking us all sorts of that, because there they have like dedicated reading days where people just sort of read, and they're like, so we're reading these, this interesting information that affects our job at the Hartford on a Friday. Can we count that as CLE? And our answer was no, because that was sort of something that was part of your typical day-to-day duties. However, if you took that and you turned it into a presentation for the employees of the Hartford, where you got together and you said, I've been reading about this series of cases that affects our insurance industry, and I want to teach you about those cases. I mean, it probably won't be that formalistic, but you get my idea. That then would count, because you've sort of gone above and beyond. So if you're reading about medical malpractice at your firm, that's just doing your job. If you take that and you put it into something more, where you're actually teaching on the subject, I think that would definitely comply. I mean, again, you have to use your own common sense about what am I delivering and what does it do? But I think my knee-jerk reaction would be yes, it would apply.
So the spirit
Yeah.
of the rule was that if you take the material, you learn, you update it, you then present it, that is continuing legal education. You've done more than just sat at your desk and read the trib and, read the cases for the day. And we loved, I mean, at the Hartford, I'm sitting there saying, can I work here?
Yeah.
There was a dedicated day to just sitting in your office, closing the door and reading about the cases, and I was, right the first to volunteer for that. So, anyway. All right, there's a, right there in the center.
Oh, you
We
would-
passed her
and
3
then-
times, and then we'll come.
If you're an adjunct professor at a college, not a law school, but
Mm.
you're teaching these specific paralegal subjects such as court or legal research or writing, would that credit towards your CLE?
So the thing is, that's like teaching at Norwalk Community College, so the question is teaching at a community college or some other school where there's paralegals and we're teaching the courses. The way that we wrote this right now was adjunct faculty or full-time faculty at ABA accredited law schools. So the way that you're going to probably get some credit for what you are doing is probably under the either seminar or under the teaching a course, but it's not going to be under the faculty member or adjunct faculty. So there's going to have to be a little bit of a discussion about that. But those are all good points. I mean, Kathy's about the,
Right, and this would be specific paralegal students, you're not just teaching a general program.
correct.
Okay.
Did you have a question?
Yeah.
And then we'll go over there, sir. Yep.
So today would be an hour and a half. Right.
Running, yep.
Um,
Not counting the stair
for
time.
CLE, it's very hard to determine exactly what portion of today's hour and a half is ethics. So if you make an assessment of it and your hour and a half is carrying over for next year, can whatever portion is ethics also carry over for next year?
Yeah, let me kind of divorce it from today's reality. But let's say tomorrow you took another CLE class where there was a specific portion of that class dedicated to ethics. So the question was about whether you can carry over any portion of today's seminar into next year's 2 hours ethics class or ethics requirement. Yeah, I will leave it up to you to determine whether you think anything today covered in ethics. We did say it was misconduct not to comply with the rule. I don't think that the whole course itself was on ethics. It was really on compliance with a new rule that has, as a part of it, an ethical obligation to comply with it. But if tomorrow you were to take just say a 1 hour class on something else, 15 minutes of which was devoted to ethics, you certainly could you've complied with 15 minutes of your ethics requirement for next year. So you only have to take an hour and 45 minutes of ethics next year.
So so an example of that is I'm teaching the civil procedure thing for this CBA course in a couple of weeks. And of that, I think there's 45 minutes or half an hour that are ethics out of the 4 hours of the program.
I get that, and that's committed.
That's
that's
easy.
Devoted, but
Right.
in this, it's sort of like.
You know something? It's gonna,
kind of
so
thing.
it is. You're gonna have to sit there and say, okay, I think it's 15 minutes of the hour really were about ethics and 45 minutes really were not. And hopefully, those of us that are presenting or those of us that have put these things together or build them for different associations will do a breakdown for people so that they don't have to do that breakdown for themselves.
That gentleman had a question.
And then back here and then back there. Okay.
First of all, thank you very much. A very informative program. I found myself wondering, for the two of you, how do you calculate your preparation and presentation time today? And I'll put that aside for a moment. But I had a more serious question. That was, I know that the practice book amendments to 27A become effective on January 1st, but I saw something that there were amendments to practice book section 717 that became effective this past July. And I wondered if you could enlighten us on that. I don't know what they are.
Section 7-17, I don't even know what part of the practice book that is, I'll be perfectly honest with you. They don't, as far as I know, apply to this standalone MCLE rule. If you have to take any type of continuing education for another, I mean, one of the classic things is if you're disciplined by an order of CLE, you can't count that also as your 12 hours. Like, so if the grievance committee orders you to 12 hours of CLE as a disciplinary sanction, you can't be like, well, I just killed 2 birds with 1 stone with that discipline. No, you've got to take those 12 hours, and then you got to take 12 additional hours of CLE. But maybe you can enlighten us. What is 7-17?
I have a notice here from Joseph Del Ciampo, the Deputy Director of Legal Services. Not quite sure what that position is, but it says, on June 24th of this year, the judges of the Superior Court adopted revisions to the practice book.
Right.
Revisions will be officially released on July 12th by being published in the Law Journal, and become effective on January 1, 2017, except that the amendments to section 717 become effective on July 12th.
Oh, okay. So
Does it have nothing to
it has
do-
absolutely nothing to do
with this.
Sometimes when the judges adopt a practice book section, they expedite the effective date of it
Of a
to
particular
July
section.
1st, sometimes it's October 1st. The typical start date for a practice book adoption is January 1 of the next year. Sometimes for reasons that I won't go into, they expedite the start date. 7-17 started July 1, but it's a completely different rule and has nothing to do with your MCO. Nothing whatsoever.
Thank you.
Did you have a
Yes,
question?
ma'am.
I'm just saying that, I'm gonna go by what this said on the website, that you can receive a minimum, today, people who attend today get 1 credit of CLE in ethics.
It's a
That
m-
can be applied.
That's fine.
Okay.
Whatever it said on, that's exactly right.
If we set it on the website, then you
Set
can
it,
say.
I'm writing it
You're
down.
dealing with lawyers here.
Yeah, I know that. Oh, no, please, I have learned that in the last couple of months, more than I really got. Yes, ma'am.
Never rely on what I say, rely on what the branch says. So there's your.
I just wanted to throw this out, that you said at the beginning, ethics and professionalism.
Right.
And coming into this and looking at the handout, and then listening to your presentation, I thought it was all about the standards for our professionalism in Connecticut
Right.
have now become this, and this is what we need to do, and here's how you comply. I saw this as basically.
It's exactly why we said what we said.
Professionalism. Well, I mean, you're saying 1 hour. I mean,
Well, you.
what's the other hour?
Well, again, and this sort of,
Information.
and this underscores a key part of this role, is that a lot of this is going to be left to your good faith interpretation. And no one is going to, if you make a good faith interpretation that you spent over an hour and a half in an ethics class today, far be it from me to second guess your decision that, I don't. I mean, now if you ask me, and that gentleman who was left said, how are you going to count it? I don't plan to count any of this towards ethics and professionalism. Learning about a new rule, to me, is not learning about ethics and professionalism. This rule stands apart from ethics and professionalism. But that's just my opinion.
Okay.
You might have a different opinion.
So it's 101, according to the answer that.
Well, the branch said it counts as a minimum towards your CLE obligation. Now, if it says a minimum towards your professionalism, it does, then take it as an hour towards professionalism. Either way, you got to do 12 somehow next year, or 10 if you carry over 2.
Yes, sir.
Mike, can you tell us a little bit more about how enforcement is going to be triggered? You talked about it in the grievance setting, and then you also said, which is the first time I've heard this, if we're being subjected to an audit. Are you talking about audit of our trust account, or is there going to be random auditing of whether we've complied with this rule?
The former. So if you get a grievance complaint against you, probably somebody at some point will ask for proof of your CLE compliance. So the question was, what did I mean when I said audit? Does that mean are we going to randomly audit lawyers to see if they've complied with the new MCLE rule? Or does audit mean by a random trust account audit, or an audit because of an overdraft in your client's trust account? And let me say qualified that it's the latter. And I only say it's qualified because if we find that lawyers are not complying with the rule, they're not registering, they're not complying with the rule, you may find that the rule gets tweaked by the judges to provide for just those types of random audits. Like, again, we all sort of pay for the sins of our brothers and sisters, but if you're here today, I assume most of you are going to comply with the rule. But for those lawyers that don't, it may be enough that down the road we have to think about a different way to enforce these rules other than passive enforcement through if you're grieved or if you have a random trust account audit or an overdraft audit.
What about, my website?
No, if you get audited for your website, that is not, we don't plan to ask you for your, but, I mean, if you think about it like especially if you have an overdraft audit, that's a disciplinary investigation. Now, a random trust account audit isn't, but that's something that they end up digging around in anyway. So I suspect you'll be asked if you have a random trust account audit, but not if you have a random advertising audit. You're welcome. Are there other questions?
There was, yeah, right.
I was just going to say, this is very much of an ancillary point, but I wonder if you guys realize that one of the things you've done is to regularize New York CLE reporting for Connecticut lawyers. And the reason that is so is New York, as you know, is 24
Right.
for 2 years.
Right.
You can do it any way you want. You guys are 12 and 12.
Right.
So what's going to happen for Connecticut lawyers who are going to obviously try to double up, they're going to do 12 and 12. They ought to thank you because I think, they regulate. There's no question about it.
I'm a member of the New York Bar. I've been complying with that for a long time.
And you see,
Right.
the reporting is rigorous,
Right.
and I think they really look at it. I think they probably look askance at someone who's got 22 hours in year 2 and 2 in year 1, so you've prevented that problem.
Well, you're welcome.
From a provider perspective, obviously, for New York, we get a certificate of attendance.
Right.
Working in a law firm, I'm actually at the admin end. Should I develop like a uniform certificate of attendance to give them? Just because I know that they're gonna want something in hand to show how many minutes are going to apply. Is that something that's recommended, or?
Well, you certainly can if you want. One of the ways that people will do it, I guess, is for the types of MCLE classes or presentations or activities that don't traditionally provide certificates, so let's say an in-house thing, there would probably be the person who is delivering the CLE would say, I've calculated it, it's worth this much CLE, and then I think if you keep track of it on this form that we've created to track your CLE, I would think that would be plenty. I mean, again, it's.
Well, we actually
Yeah.
track it for New York and for other states that are admitted
Mhm.
as well, and we're even thinking about getting, one of the vendors who provides CLE tracking. So when you think of it from that perspective, the attorneys are not going to be tracking it individually, it's probably going to be on someone.
I know the Connecticut Bar Association's offering a tracking service so within the CBA, I got a notice about this, on your own membership, you'll be able to put in all the CLE that you want, and they'll keep track of it within the CBA.
Yeah, I mean, if you work for some place that tracks it for everybody,
Right.
that's okay, provided that if anyone ever asks for it for an individual, it can be produced. Because that individual has an individual responsibility to maintain record proof of compliance for 7 years. So that's the only thing to keep in consideration.
And the object was not to have to keep a whole file folder, but if you have one piece of paper that's got everything on it for 1 year, and you scan it in, put it in your computer, it's going to be easy to have.
But if you have certificates, it's good to keep those as well.
That's fine.
And then just a second question, going back to publications, would you consider a book supplement, a legal book supplement to be a publication?
Yes.
And then, is there a limit to the amount that
So,
you are
we should-
going for publication?
So the question's about book supplements, do they count? And the answer was yes. And I'm sorry, the follow-up question was?
Is there a limit to the amount of credits that you can apply towards a book supplement?
Is there a-
Because publications, for instance, in New York,
Yeah.
you're limited to 12.
Right.
So is
think we said
there
6.
a
No,
limit,
it's
or
just for
because also
teaching,
you have the ethics
preparing of teaching
component,
seminars.
if you're not writing something on ethics, are you missing, do you only get 10 and you have to still comply with 2 credits of ethics?
No, you
Or
might,
just-
you might be able, so the question was, is there any limit? And then was about ethics. So there isn't, the only limit in the rule is you can only take 6 hours for teaching a seminar. Okay, so if you take your whole 12 hours or 16 hours to prepare this book supplement, and it would count, there's 16 hours. Now, if you haven't done 2 hours of ethics professionalism by that preparation, you still have to take 2 hours of ethics professionalism. But if you do that, you can carry over up to 2 hours that you spent working on that supplement to your greater 12-hour requirement for the following year. But no matter how much CLE you do, If you haven't done at least 2 hours of ethics professionalism, you got to add 2 hours of ethics professionalism. Anybody else?
Any other questions?